Well, I think we are winning, but there's still more work to do because the Inspectorate of Police, Sir Andy Cook, has said that the police need to use common sense and decide what is a crime and what's offensive. But as I say, there's still more to do. But in that regard, please do subscribe to my channels here because there's still more work to do here as well. Thank you all so much to subscribing to all of my channels. I think not all of you are familiar with all of my channels. Yes, I do a lot of YouTube. I enjoy YouTube, and here we are. So let's talk about this, shall we? Because the Inspectorate of Police, Sir Andy Cook, has said that they need to scrap the non-crime hate incidents because I've said all along I think they are a bit ridiculous because they don't meet the criminal threshold, but they are recorded against you nonetheless. Now, that itself has its own legal implications, and I think scrapping them doesn't go far enough. I think, with the greatest respect, police across the board need to be educated to what is a crime and what is just something that is offensive. And they are not the same thing. But as I said, I think we are winning because Graham Linehan has had his bail conditions removed, which was that he was not allowed on X. But there is still more to do there as well. So let me take you to this story here with the Telegraph. The Inspectorate says that they need to scrap non-crime hate incidents. He says they should be scrapped and urges forces to use common sense and focus on the issues that matter to the public. I couldn't have said it better. And sometimes, as I joked in one of my posts earlier today on X, I wonder whether they watch my videos. At least I hope they do, because perhaps police across the board could look to what the law really says and what really is criminal and what isn't. Because as Sir Andy Cook here says, police publishing this annual report, he says that public confidence and trust remain too low, and officers need to be more visible and responsive to community concerns, and they need to separate the offensive from the criminal. Because, as I've said many times, being offensive is not an offence. And yet recording a non-crime hate incident against you, whilst it falls short of being a criminal thing, it does have rather a chilling effect on free speech. And I've known a lot of different cases where people have been warned. There have been given community warning notices. If you do or say this again, we will come after you and prosecute you. And this has even been the case where somebody has been, let's say, doing something to their own fence. With one story that we had come to us where it was their fence and they wanted to stop their neighbor from painting it or doing something to it. They had a discussion about it and they were given a warning, a community warning, that they'll be prosecuted for harassment if they continue doing that. And it was their own fence. Really bizarre situation. But coming back to public order offences, I've done this in a couple of videos, so I'm going to go a little bit further in this one with a little bit extra. We're talking Public Order Act, Section 4, 4A, and Section 5. Section 4 involves the unlawful violence, and Section 4A is not unlawful violence, but still has an intent requirement, and Section 5 is the lesser of those three. But let's take a look at the one smack in the middle. I keep using the wrong screen. This one here. I'm using different screens so you can see more of it. This one here, Section 4A. Now, I've said before that there are defences available, and one of those defences is that if the conduct was reasonable. But then some people will say, well, what defines reasonable? Isn't that also a subjective term? Well, yes, but there's also some guidance on that as well. And here, with the greatest respect, is where police across the board need to be familiar, because this is the practitioner guide for this offence. And so this is used in an educational context here alone, not legal advice, you understand. But a person's conduct will be reasonable if the person is exercising ECHR rights in the circumstances which an interference with that right would not be justified under Article 12.2. Those are the qualifications on the right to the freedom of expression. Now, as I mentioned before, some rights are absolute. You have the absolute right to life, for example, but your right to the freedom of expression may be curtailed in law, given that it might be necessary. Now, that just doesn't mean someone might be upset by it so they can restrict you from saying it. That's not what it means. But that's how it's been applied recently, in my view, when I hear stories online. So let's take a look at what actually applies here. Let me zoom in a little bit more so you can see even better. I've been recommended to zoom in so you can see these things. Under freedom of expression, this is Article 10 of the Human Rights Act. To exercise these freedoms, since it carries duties and responsibilities. I mean, many things in law have both a corresponding duty and responsibility. If you have the right to something, there might be a duty and responsibility attached to it. It says the exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to formalities, conditions, restrictions, or penalties as are prescribed by law, and here's the important bit, and are necessary in a democratic society in the interests of national security, territorial integrity, or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, or for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. So there are certain limits to the freedom of expression. You'll note that in none of those it says that someone is offended, someone is upset by something. It really goes to things like crime, things like protecting health. The slightly ambiguous one here for the protection of the reputation or the rights of others. Now, that is coming to the law on defamation. So, for example, you have the right to say something that is defamatory. You could say that this person is a fraud, this person has committed this offense or whatever. You have the right to say that. But also, there are consequences. So under the Defamation Act, you may be sued for defamation. So this may be curtailed, or there may be duties, responsibilities, and other restrictions as per the Defamation Act, by way of example, to protect the reputation and the rights of others. You'll notice that in none of those things did it say that someone is offended or someone is hurt by it, someone just doesn't like what you're saying, they object to what you're saying. None of those things are included. It does include things, for example, such as to prevent the disclosure of information received in confidence. So this might be trade secrets of a company, or it might be someone has eavesdropped on a private conversation, and that conversation or conference, if you will, had a necessary quality of confidence about it, and the information should really not be imparted to anybody else or disseminated to the public in general. And therefore, the court might look at that and say, well, we see your right to the freedom of expression under Article 10. However, in this particular situation, that might be imparting information disclosed in confidence, and therefore you are now prohibited from saying it. So it may be curtailed in that way, whereas in any other sense, it would be a restriction on that freedom of expression. And so with the greatest of respect to all police that may come across this video here, or any of this in general, and if you share it, they're more likely to come across it. It is a defense under Section 4A to use this one as an example to show that the conduct was reasonable. You'll also note, interestingly, that under Section 5, which is another harassment, alarm, distress, without the intent requirements, that's just where a person is guilty of the offence if they use threatening, abusive words or behaviour, disorderly behaviour, etc., any sign that any person is likely to be caused harassment, alarm, distress. There is also a defence here, several defences, statutory defences. Firstly, that they had no reason to believe there was any person within sight, hearing or sight likely to be caused alarm, harassment, alarm or distress. Secondly, that he was inside a dwelling and no reason to believe the words would be heard outside. And thirdly, again, similar to 4A, that the conduct was reasonable. So again, if it's just the exercise of the freedom of expression and there's no reasonable curtailment in law or other restriction in law of that speech, then again, that conduct is reasonable. You'll note that that reasonableness bit is missing from Section 4, the fear of provocation or violence, where a person is guilty of an offence if they use towards another threatening, abusive, insulting words or behaviour with the intent to cause the person to believe that immediate unlawful violence will be used against him or another or by any person, etc. So the reasonableness disappears because they have to prove the intent to cause someone to believe immediate unlawful violence. So that reasonableness bit disappears. But as I said, I think we are winning because coming back to the article here, Sir Andy said the general public want forces to concentrate on the issues that mattered, such as reducing street crime, antisocial behaviour, shoplifting and violence. He says police need to get the basics right and focus on the issues that matter to the public. I think we need to separate the offensive from the criminal. We need at times to allow people to speak openly and without fear that their opinions will put them on the wrong side of the law, which is exactly what I think many people fear today. He says, I'm a firm believer that non-crime hate incidents are no longer required. I would firmly agree with that view. He says that intelligence can be gathered in a different way, which would cause less concern to the public and make recording of such issues easier for policing. Further down in the article, here's a bit that I somewhat disagree with. I mean, I agree with the principle of the thing with Sir Mark Rowley here, the Met Commissioner, where he accused successive governments of leaving the police between a rock and a hard place by failing to provide clear guidance around the laws and social media crimes and so on. Now, with the greatest respect, as I've mentioned about other judgments before, I actually think the law here is very clear. What Sir Rowley is saying here is that there isn't sufficient guidance around the law about what people say online with respect to, say, malicious communications, for example. I think the law is actually quite clear because the malicious communications offences need to be a bit more serious than those that are being looked at the moment. And I say that because when we look at these offences, they're actually relatively straightforward if you look at them with a common sense approach. The primary one, Section 1, Malicious Communications Act 1988, a person who sends to another person a letter, electronic communication, article, or whatever, which conveys a message which is indecent or grossly offensive, or any article or electronic communication which is indecent or grossly offensive is guilty of an offence. Now, indecent or grossly offensive should be relatively common sense to understand. This is certainly not something that should be confused with someone posting a comment online that upsets somebody that they disagree with, they take objection to, or they feel somehow enraged by it. That is not what that act and that offence is intended to prevent. Likewise, under the Communications Act, here's another one that I've seen bandied about under Section 127, improper use of public electronic communications network, whereby, again, where people are posting things online, I've seen people accused of these offences, which is where a person's guilty of an offence if they send online a message or other matter that is grossly offensive or of an indecent, obscene, or menacing character. Now, again, if we take these words by their ordinary meaning, grossly offensive, that is not just someone upset by something. It's not just they find it offensive. It has to be grossly offensive, really serious, or indecent. So clearly, by way of example, if somebody sent unsolicited naked imagery, or worse, use your imagination, if they sent that or posted that or whatever, that's indecent and obscene. And if it was something else like attacking an animal or something and they designed that to upset somebody and it was grossly offensive or a menacing character, this is what these offences are designed to prevent, not simply making a statement that someone disagrees with. And there is a line, it is a high bar, but this high bar is where we draw them up as criminal offences. So progress it is, enough it is not. Let's go back to what Sir Rowley said here. So he did back Sir Andy's call to scrap non-crime hate incidents, saying police should be given more discretion on what they record and investigate. He said the law at the moment gives a limited amount of discretion if someone reports what they think is a crime. Now, I somewhat disagree with great respect there. I think there's a little bit more flexibility than he is saying so here. He says here, the law at the moment gives a limited amount of discretion if someone reports what they think is a crime. There is little flexibility for an officer to decide whether they record it. Now, I don't really agree with that. If someone posted online, you're an idiot for posting whatever you posted, and they reported that to the police have a very broad discretion to dismiss that and say, I'm sorry, sir, or madam, that is just not an offence. That is not something that we look into. It doesn't come near crossing any kind of criminal threshold. And this is no further action. There's no need to record it. There's no need for a crime number. Where I do agree, however, is where he says it's time to look again at the policy and legislation around these issues, warning that the police are currently being placed in an invidious position. Now, there I do agree to an extent, because I do think we need to look at the legislation to ring-fence and protect free speech, to prevent any of these offences being charged and pursued just because of what someone has said in public or online. But I am very pleased to see the reference to common sense. He says, as we know, discretion and common sense don't always win out in these issues. He said there were many distasteful and offensive things published online, and it was the police's job to deal with criminality across the board. Now, I hope that they are not conflated, because distasteful and offensive things online are not criminal. So they are not criminality that the police should be dealing with. These are just things that people might be upset by. That is the very nature of free speech. He then goes on to say, I do believe this is a once-in-a-lifetime opportunity to actually start to reform the policing needs, and it'll be a missed opportunity if it's not properly funded from the start. So I do agree that we need to look at the legislation. We need to ring-fence free speech, make it stronger, prevent the police from having to get involved and waste time. I have proposed to restore Britain to assist pro bono in drafting, redrafting legislation, or even drafting new legislation to assist in that regard. I'll let you know how that goes, whether that's taken forward, but that is something I'm prepared to look into. But for now, I really appreciate your support in doing all of that by subscribing to my channels and watching my videos and sharing them with someone that you think might find them useful, even if, and I know some police do watch my videos here, so I'm humbly grateful to all of you that do that. Please do share it around so that officers are familiar with what the law says and the limits that it should be applied, especially the newer officers that may be unfamiliar and may have the wrong impression that they need to police everything that everybody says. That is simply not the case. So thank you all for watching, and I'll see you next time.